Tēnā koutou, tēnā koutou, tēnā koutou katoa. Welcome to everyone for this penultimate seminar in our series, the Wellington School of Business and Government Funded Chair series on Sustainable Development Goals. And it's a great pleasure to have Associate Professor Jane Bolitho, who is now able to talk to us after only arriving into New Zealand earlier in the year. And it's great to see so much interest from both people in the university and outside the university in this topic. So the topic for today is restorative roadmaps for the promotion of peaceful and inclusive societies and justice for all. Jane is the Diana Unwin Chair in Restorative Justice, one of our funded chairs. Arrived early in the year and is now already making quite an impact with some of the exciting work she's doing. She will speak specifically, sorry, this always happens. She will speak specifically to SDG 16, Peace, Justice, and Strong Institutions. And hopefully that link is somewhat clear. And with just this brief introduction and a little bit of context, I would like to hand over to Jane.
Thank you, Christian. Can everybody hear me okay? Tēnā koutou, ko Jane Oho, ko Bolitho te whānau. Ka nui te mihi ki a koutou, tēnā koutou, tēnā koutou, tēnā koutou katoa. Hello and welcome to everybody listening. Many listeners will not realise, but it's actually International Restorative Justice Week, which is celebrated globally. Just a wonderful coincidence in timing. So happy Restorative Justice Week to all of us. I'm so pleased to have this opportunity to talk about the UN Sustainable Development Goal 16 and to reflect on restorative justice and how our work in the Diana Unwin Chair progresses this goal. There are many positive aspects to our work that I will share, but I have applied a quite critical lens to the role and scope of the chair, and by the end you'll see that there are more questions than answers, and although somewhat uncomfortable, these questions provide the impetus for shaping our next steps. The presentation will move through three parts. In the first section, we'll look at the Sustainable Development Goal 16, SDG 16. In the second, I will outline my understanding of restorative, which will give us a common context for considering its potential in working towards the goal. In the third part, I will take a step back. And conference now. In the third part, I'll take a step back and consider the chair's role within the unique context of Aotearoa, and I will contextualise our achievements within the bigger picture of human rights in this country. So that's a bit of a roadmap for the presentation. It will go for about 30 minutes, so there's a little bit of time left over for some discussion. I have assumed that in the audience there are people that know nothing about restorative, and some who will have a very deep knowledge, and perhaps even for whom restorative is something that they have experienced as a participant. So I've pitched the presentation to balance these different starting points. So let's take a look now at SDG 16. To promote peaceful and inclusive societies, to provide access to justice for all, to build effective, accountable and inclusive institutions at all levels. The first part of SDG 16 is levelled at the functioning of society. It's not assumed that conflict, harm, wrongdoing and crime doesn't occur. After all, the sociologist Emil Durkheim noted that if we tried to imagine a society of saints, we couldn't. It would be impossible, because even were we to live amongst angels, When living in community, the most minute of differences would eventually be noticed, leading to labelling of that difference, and then depending on the extent of that difference being perceived as problematic or harmful, the process of othering would occur, as would the development of a shared sense of norm violation and possibly then a distinction or label of criminal. So from noticing difference to the labelling of events as harmful and then harmful enough to criminalise, this is a universal human activity. Even with harm and crime being subjective terms, hurtful activities, whether given the label of criminal or not, will always exist. But a marker of the moral well-being of our society is how much and of what kind of harm, hurt and crime is occurring, and how often and to whom, and then to which methods do we turn to address these harms. The second part of SDG 16, providing access to justice for all, has three important ideas. Justice is a very complex word that has everyday meanings and connotations as well as a legal frame. And then there are even higher level meanings to the word justice that philosophers like to use when trying to tackle the big moral dilemmas of our times. So just taking an everyday understanding of justice, it's fair to say that the human need for the righting of wrongs exists. Using a legal lens, justice in the form of some kind of accountability is important to the right functioning of our community. And so we have a legal system. I often use the term legal system because the term criminal justice system suggests that justice is enacted every time, and this is not necessarily the case. Even if you were to have the best justice system in the world, you still have to be able to access that space. So the second idea in this part of SDG 16 is that your ability to access justice, your capacity to find a pathway to the space which addresses harm, it matters a good deal. Here is where I think a link between the higher level philosophical debates on justice are useful. Specifically, I'm interested in the work of Amartya Sen and Martha Nussbaum and the so-called capabilities approach. The capabilities approach is congruent with the human rights framework, but instead of asking which rights exist and mapping those, the existence of those rights to jurisdiction, it drills down to the actual capabilities of each person to enjoy rights and freedoms, including justice. This might sound quite individualistic, but we can use the capability approach, the capability framework, to look at patterns of access by attributes such as race, ethnicity, gender, sexuality, and disability. So that's a bit of a higher level point. In a more operational or practical sense, the legal and justice practitioners and workers in the audience will be familiar with the idea or notion of a justice funnel. Across the globe and in this country, it is a fact that many crimes are not detected. Many crimes will not be reported. Many cases do not proceed to prosecution, and of those that do, only a fraction will end in a finding of guilt, being of course only an issue if the crime did actually occur, so a false negative. I'm sure many lawyers in the audience are kind of muttering, the law is the law. But from a human perspective, this funneling of matters through the criminal justice apparatus of police and the courts and sentencing leaves many instances of harm at loose. They're simply not attended to. Now, this would be fine if we only cared about the legal truth, and if we knew that this funneling was a natural and right filtering of all matters. Unfortunately, that funnel is more prominent for some kinds of crimes than others, and in turn, crime affects some people and some groups of people more than others, and the attributes that determine the likelihood rest on intersections around age, gender, race, ethnicity, sexuality, socioeconomic status, neurotypicalness, and so forth. So technically, while we're equal in the eyes of the law, it is not the case that we are equally likely to be impacted by harm or crime, nor do we have in reality equal access to the mechanisms that bring so-called justice. So there is some complexity to the second part of SDG 16. The third component of SDG, building effective, accountable and inclusive institutions. It reminds us that since the Industrial Revolution, organisations, bureaucracies and institutions have come to hold an immense power in the shaping of our lives from birth to death, from hospitals to education and schools, to workplaces, to the institutions that we rely on for access to resources and support in times of need, to our formal justice institutions, the law, police, courts and prisons. Well-functioning institutions support well-functioning communities and people. In recent times, though, in Australia, where I'm from, and in New Zealand, we see Royal Commission after Royal Commission questioning the functioning of these very important institutions. We are seeing right now the product of hurt and harmed people, harmed under the watch of our most trusted institutions. I've just popped a few of them up here on the PowerPoint, by no means all of them. In New Zealand, the Royal Commission inquiry into abuse in care. To have children and young people in care being abused is really quite devastating news indeed. Not least, there is an additional aspect to it, which in the criminal justice sphere is understood to be around the care and crime nexus. Those coming into our care system end up in the criminal justice system. So to know that there is abuse as well is just many compounding harms. The Australian Defence Abuse Task Force, or the DART model as it was known as, established in 2012, looked at all of the issues of abuse, not just sexual abuse, physical abuse, any abuse, up until 2011. 2,500 complaints were made, 700 restorative engagements were completed. We've got a Royal Commission into institutional child sexual abuse. We've got a Royal Commission into detention centres. We've got a Royal Commission into banking, superannuation and finance. We've got a Royal Commission into the aged care sector. And most recently, I read of in Victoria in Australia, a redress scheme being set up to address the systemic gender and sexual harassment claims within the Victorian police system. Now, the fact that our institutions are being questioned and held to account means that there's no shortage of work for people like me in the restorative justice sphere. We've picked up a lot of work. Yet another sphere along the same lines is developing, which is around us working with sporting institutions and organisations that have enabled abuse of sports people, including at the very elite level where there's been government oversight. These kinds of matters are congruent with what the US Olympic gymnast Simone Biles brought to the world's attention in Tokyo earlier this year. One of my Kiwi colleagues asked me recently if there was something wrong with the Australian culture, that so much institutional abuse was occurring. But I don't think that it's endemic of Australia. It's the result of a confluence of factors, including the rise of social media and things like the Me Too movement, which are fueled by people power and suddenly kind of having a capacity to shine light on previously invisible harms. So I'll talk a bit later about the capacity of restorative to meet the unmet justice needs of harmed parties through these various royal commissions. But that's kind of that's a bit of an interrogation of SDG 16, I suppose. Why is restorative justice relevant to this goal? Well, to answer this question, I'd like us to have a shared starting point on what restorative actually is. Okay, so for me, restorative is best understood as a philosophy that sparked a social movement, a global social movement, and one that's really taken off since the 1970s. The origins of the movement are diverse and, of course, somewhat contested. Suffice to say that since the 1970s in Western democratic countries with adversarial legal systems, restorative programs began to proliferate. If we were to look at restorative used in the criminal context, today restorative justice programs of some sort or another are a formal part of pretty much every youth justice system in the world, and to nearly the same degree sitting there as an option for adult offenders as well. Now, New Zealand is recognised globally as an absolute leader in this sphere, not least because of the Sentencing Act, which enabled the adjournment of every eligible case to restorative. So it was an opt-out rather than opt-in system, leading to a huge increase in the number of restorative referrals coming through. So the sheer volume of restorative initiatives, along with the pace of experimentation globally, arguably makes it the most significant justice innovation that we've seen in modern times. Before going further, just a quick note on terminology. You'll hear me using the term restorative practice and the term restorative justice. While the early writings in the field related to crime and justice, the ideas were quickly transplanted into the civil and community domain, most notably in the education sphere and in workplaces, in transitional conflict matters, and then more recently even to into healthcare systems. So it might be useful for you to imagine that restorative practice is the umbrella term, and for all of the initiatives that use a restorative philosophy to address harm, and restorative justice is the term that we use for matters that have some kind of intersection with the legal system. Restorative practice is the preferred term when we're talking about strategies that prevent harm, proactive pieces. Whereas restorative justice, at least in New Zealand, is a term that tends to refer to reactive work that's happened after a crime has occurred. Still quite a live international debate on this terminology, but we don't need to get too bogged down in that today. Our work in the Diana Unwin Chair sits across all of these areas, and so we generally use restorative practice. The United Nations defined RJ back in 2002. In the most basic sense, it's a facilitated conversation between somebody harmed and somebody responsible, or people harmed and people responsible. To complicate this a little bit though, restorative is more than this. It's a philosophy that rests on particular principles or values. So operationally, we can say that any process that reflects the principles is at least somewhat restorative. So there's a continuum. The core principles or values on which restorative rests are that every human being has dignity and worth regardless of deed. In restorative, there's optimism about the redeemability of people. And while each of us has a capacity to commit really heinous, shocking crimes, leaving kind of in the wake, grief and trauma and shame and loss, each of us also has a capacity to kind of be resilient and to survive and to have courage and to have hope for a better future. Another kind of restorative value is that humans are social and relational beings, that we thrive in networks and community, and we suffer when in isolation and in alienation. If you imagine kind of like a spider's web, when a crime occurs, it's like the spider's web is being shaken, and in restorative, the obligation is on the community and the person to rebuild that web. It's not just for the state to rectify things. The parties to a restorative encounter are given the opportunity to have a direct say, to have voice, to have communication about what happened. It's not mediated through any professional voice. It's not through the lawyer, not through social workers, not through psychologists. The idea is that in narrative, in storytelling, we're seen. And this is quite different to what happens in the adversarial system, of course, where the state takes on the role of the victim and we have the Crown versus the defendant. So another principle of restorative is that the conversation moves in a loosely structured way through what happened and the impact and the way forward. But any agreements around what the way forward could look like would need to be arrived at consensually and in a very deliberative manner. Outcomes are never done to someone. They're not kind of top down. They're arrived at together and they come from the people that have been most affected. Another principle is that it must be voluntary. It's never coerced. That's participation, that is, and that there must be an acknowledgement of harm from the beginning. And that's because restorative is not a fact-finding mission. It's not a mechanism to resolve a dispute. That's what makes it different from mediation. In restorative, it's accepted that there are multiple truths to an event. And while a legal truth may be sought or arrived at or not, what is important in restorative is a genuine acknowledgement of some kind of harm, allowing then for an outcome to be much more targeted, personal, and much to kind of lead to a much deeper form of accountability. So overall, restorative is a mechanism for achieving justice, and it's also a kind of justice. And I don't want to speak to the vast literature on why restorative works. Just very briefly, the simple act of giving voice to the parties affected by harm, letting stories breathe, is really useful in healing. Spaces that are set up in a restorative way nearly always bring a perception of procedural justice, and there's a big legal literature on why procedural justice matters. It's also the case that when you create this space and you give people voice, there's also space for very kind of careful and considered listening. And in the trauma literature, we can talk of this as kind of bearing witness to something. And these can feel very powerful and moving and be quite transformative. And then restorative also just works because in looking at a person in context, at a very practical level, you can kind of build evidence-based supports around that person. So for both the person harmed and the person responsible, so that there's support into the future for it not to happen again and for that there to be some healing, I suppose. Now, many of you listening will be well familiar with the philosophy of restorative, but even for people like me that wake up every day and think about restorative, the volume of restorative services can make it hard to see the wood for the trees. And that's because restorative can have different names, it can be called different things, it can be offered in community, it can be offered alongside the legal system, it can be offered instead of the adversarial system. In the criminal context, it can be diversion, pre-sentencing, as sentencing, or post-sentencing. It can consist of a single meeting or many meetings. It can consist of a face-to-face encounter or an exchange of letters. It can begin with the needs of a victim and bring in the person responsible optionally, or it can begin with the needs of an offender and have optional participation for the victim. It can be done with surrogate victims, which might be a bit of a stretch for some of you to imagine, but it's with the victim of a similar kind of harm brought into conversation with somebody responsible. Then increasingly, we see that with something like abuse in care, there is, in a sense, multiple persons responsible. And we see victims wishing to have a facilitated conversation with a representative of the institution within which the acts occurred, perhaps even more than desiring a conversation with a direct perpetrator. So a good example of this has been through the Catholic Church across the globe, in many, many instances of child sexual abuse. And a number of victims have wanted to meet with a church representative rather than the actual perpetrator, who in many cases deceased or incapacitated through old age. They wanted to meet with the institutional representative because the impact of the crime was not just physical or emotional, but through things like a loss of faith, which is an important part of kind of a good life. So restorative for those people. So restorative engagement then offers a space to kind of to remedy losses on many different levels. So the restorative field is super diverse, but for me, the beauty and power of restorative is just in how flexible it is as a mechanism for meeting these really, really diverse individual and community needs. So I'd like to turn now to considering how restorative can be used to help achieve SDG 16. So the examples I'm going to use are examples that we've had that we've worked on in the chair. First, and in a very blunt way, the existence of another pathway to justice means it is very likely that more justice will be done, more justice will be available to the community, more people will find a meaningful resolution to matters that hurt and harm. Having restorative as an option offers a different avenue to resolution. It offers another avenue for those matters that are reported but not taken forward for prosecution. It offers something in the space for those that are affected by hidden crimes. All of those matters which exist but which aren't recognised to be criminal or even detected sometimes by the parties affected, and for those matters where there's no legal or civil recourse. So one example would just relate to the very worrisome evidence emerging around the globe and in this country around the abuse and neglect of elderly people in nursing homes, in residential care, but also in our homes in the community. Abuse can be physical, it can be sexual, it can be emotional, it can be financial. For all sorts of reasons, many of these matters aren't going to be taken through the adversarial system, yet there needs to be some form of accountability, and certainly the behaviour needs to be stopped. So the chair did some really interesting work on elder care and using restorative to attend to these kinds of harms. Another example that I've worked a lot on in my research work would relate to sexual violence, which is a violent crime that is the least likely to be reported to police, probably because it's the crime that's perpetrated most by people known to the victim, so partners and family. Now, I'm personally in favour of many, many reforms to the legal system and the criminal trial around this topic, but it doesn't mean that my experience working in this field with survivors, through that experience, I've come to understand that what people need and want is choice and support to make the choice that's right for them at that point in time. And it's a simple fact that many women in particular will continue to not report sexual and family violence, but want the behaviour to stop. So this is where restorative can come into play. There are also perpetrators who would like to desist. So even when not under the shadow of the law, in community I'm talking about, restorative can be done. It is not easy work, it's very complex, there are legal tensions, but there are existing specialist services. Wonderful example in this country being Project Restore. And this is absolutely a step in the right direction in terms of access to justice for all. A different aspect on sexual offending relates to the rehabilitative options available to perpetrators, of which there are fewer than what you might expect. there are so many causes of sexual offending. We have a tendency to lump them all in together, often into the category of irredeemable, and many restorative services will simply exclude any sexual offending matters. Yet one of the few areas in restorative where randomised controlled trials have been done is around a particular form of restorative done for offenders called Circles of Support and Accountability, or COSA models. We're not following the evidence based on this one, whether it's through the perceived risk or the distress people have with this topic. Yet an inclusive society means supporting people to not reoffend. We know that our prisons don't help us here, so we must use the evidence. Another example that we're doing a lot of work on in the chair is in the health sphere. The health group in our team work to address unexpected outcomes or adverse events, whether they're one-off, or such as in the kind of tragic cases of stillbirth, or multiple instances where a whole cohort of people are impacted, or systemic harms resulting from ongoing organisational changes. A major piece completed with the Health Quality Safety Commission for the Ministry of Health concerned surgical mesh, for those where complications arose after surgical mesh implantation, and the impact on everyday life was immense for these people, immense and ongoing, serious losses to physical well-being, relationships, identity, emotional and financial implications, and also a loss of trust in healthcare providers. So that project supported over 600 mesh injured people to share their stories, and space was also created for family of people affected to have some voice and to get to gain some acknowledgement of that harm. So this restorative engagement work not only provided an avenue for voice, but also shaped a reform agenda for the health system to prevent future events. And so a wonderful short film that was released on this project just is up on the PowerPoint there. Moving to point 2, it's also the case that all of those are examples of restorative bringing us access to justice, but restorative also works to achieve the promotion of peaceful and inclusive society by giving us a way to attend to everything that's left over after a complaints or dispute resolution or a legal adversarial finding has been made. So even when there is a guilty finding at court, or a dispute is settled, or a claim is assessed and technically resolved, time and time again we hear that the human needs of harmed parties are not met. In the legal system, many victims need information about what happened and why. Many people need to negotiate safety, particularly if they're going to see each other again. Many victims need to be believed, to be seen, and to be heard. So restorative justice can meet these unmet needs of all of those affected by harm, regardless of what finality a legal truth can offer. So one very small example of a project that we've done in the justice sphere related to the contribution to the work program of Whakamana Tangata, a program that brings some restorative principles to the experience of youth detention, working off the principle, of course, that youth detention is a legal reality, but not something that meets human needs. And finally, point 3, restorative can offer us a tool to prevent harm happening in the first place. So this very squarely then helps us achieve goal SDG 16. Here at this university, which is a restorative university, there's been some really amazing innovative work in the residential halls. The pilot was called the Sustained Restorative Dialogue Program, aimed at really preventing sexual violence occurring on campus through co-designing conversations that matter with residents of the halls, educating around sexuality, educating for consent, and pathways to support if harm occurred. So in all these ways, theoretically and practically, the restorative works to the goals of SDG 16. So, on a positive note, the Diana Unwin Chair, we support restorative work from birth through to death. We support the use of restorative in community, as well as services that are kind of enmeshed in our government systems. And we support work done in organisations, and we support proactive work as well as reactive work. And all of these pieces of work, I'm super proud of and really happy to talk of them. But while our projects contribute positively to New Zealand, if I were to kind of stand back and consider the broader picture, a number of indicators point to us failing. There are differential outcomes for people in this country in terms of health, education, employment, housing transition, and a gross overrepresentation of Maori that are incarcerated. Just last week, I read a report on the New Zealand Human Rights Commission website, and it's still on the front page, which found that Maori and Pacifica women face disproportional periods of segregation in New Zealand prisons. With 93% of segregations in prison lasting for more than 15 days, this actually constitutes torture, according to the United Nations. So if we consider that women in prison have complex health needs resulting from being in care often as children, and many with histories of sexual abuse, intergenerational trauma comes to mind. And this situation is just not acceptable. So meaningful work towards goal 16 must be predicated theoretically and practically on meaningful interrogation of our obligations to uphold the Treaty of Waitangi, and a meaningful assessment of whether those obligations are being upheld. An overrepresentation of Maori in prison and of Maori with worse health or employment trajectories is a signifier to us that all is not well. If it is the case that many New Zealand scholars have argued that the genuine intent of iwi and hapu when signing to treaty, and the understood meaning of the treaty is now the understood meaning of the treaty is now overlooked through ignorance or purposeful disregard, we have a moral imperative to rectify this. Saying that we're operating in a treaty-led fashion is also not quite enough because of these First Nation concerns about these different constitutional understandings at play. So therefore, the work that we must engage in is the task of what many white settler folk, like myself, have termed decolonisation. Noting, though, that those such as Moana Jackson in this country have pointed out that First Nation scholars do not need pakaha, like me, to frame the issue or to label it. Moana Jackson suggests an alternative language for this piece, which for him is termed an ethics of restoration, which is rebalancing towards what ought to be and to working to what was actually intended when iwi and hapu signed the treaty. So for someone like me in a very privileged position with many resources to draw from in a university and in a chair role, which is in partnership with 7 different public sector agencies, I am wanting to take heed of the international and national call for restorativists who are naturally peacemakers to engage much more deeply with their warrior spirit in order to really challenge and transform social and racial harms. A different set of questions are probably going to need to drive our work agenda. What can a restorative lens offer by way of tools to do this work of decolonisation? How can white practitioners develop skills to identify historical and system harm? How do we become conscious of our own biases and more skillful at disrupting the nuanced ways in which we reenact them? What are the names and meanings of existing iwi and hapu concepts for dispute resolution, mediation, peacemaking, and restorative type work? Can restorative work alongside tikanga Maori in addressing harms? Can a negotiated space model represented with the dual hulls Waka here in this PowerPoint be a useful frame for us? Who would like to be part of this conversation? How can we in the chair enable and support those courageous conversations into actually happening? What is our role in driving a human rights and capability building agenda in Aotearoa? So in conclusion, a restorative agenda that ignores inequities will be perceived as uninformed, uncaring, irrelevant, maybe even racist. Success for us will need to rest not just on individual transformation or singular great projects, but on true systems change. So I'm going to leave it there and just open the floor to discussion. I've finished right on half an hour, so there's a little bit of time for questions. Thanks.
Wonderful. Thank you very much, Jane. That was excellent. And it was great to see it so interwoven with the SDGs as a real engagement with SDG 16. Now, we would like to open the floor for questions, but for practicality reasons, we've learned in the past that it is best to do this through the chat function. And I'd like to start with a question by Laurie Magnus, who firstly says it's really good to start with the SDGs as a way of connecting all of this to human rights and other conventions that we're signatory to. And she follows up with a question about the commissions, the royal commissions. Do they name the systemic discrimination that has led to the type of abuse? And do they then also put processes in place to stop it? What is your insight into this, Jane?
Can I check, Christian, is that a question about institutional organisations that have been called to account?
I believe so. I mean, it's in the shared function. So the Royal Commissions, when they talk about systemic discrimination, do they identify it and do they put measures in place? I suspect the question is about identifying the underlying causes of what happens rather than just dealing with symptoms.
Yes. Okay. So by no means am I an expert in royal commissions, but in general, there are large panels of very expert and elite kind of judges and magistrates sitting in the role of royal commissioner, and their job in hearing stories and is to kind of do that piece, which is trying to look for patterns in particular institutions, in particular churches or faith-based groups, in particular sporting organisations, particular schools and education systems. They hear all of the evidence and will be able to put it together, and in their final reports do make recommendations that look at the systemic issues in each of those institutions. The restorative part kind of comes after that, which is in the redress package, and sits at a different level. Yeah.
Laurie, did I represent your question appropriately? Okay, thank you. It took me a minute to get my head around it. Excellent, thank you. And then a new question has come in from Lewis. Can restorative practices be used in a transnational setting? I'm thinking along the lines of diplomacy strategies with dispute resolution. If so, what can New Zealand or the Aussies do to be more effective in this space? Very interesting.
Yeah, very interesting question. And yes, absolutely, it can be done and it is done. And it's certainly probably more in the European in some of the European, in the European forum, we see some of this. It tends to be, trained negotiators and peacemakers bringing in restorative as another tool to their belt and to using that lens when they can in the field and then in complex negotiations. Defence were, interestingly, a funder of the chair back at the start for this very reason, that of course, any time that there's conflict, crime, harm happening, restorative can be brought in as a useful tool to kind of to attend to some of that.
Excellent, thank you. And while the new questions come in, there's one. A question from Sasha. With regards to the Christchurch mosque attacks in 2019 and its roadmap to restorative justice for victims and communities, what would be some of the indicators that might be useful to monitor how restorative practice can be achieved meaningfully for affected communities and in New Zealand's action plan against racism agenda as a whole? Sorry, so I said restorative practice, but it was restorative justice. Hopefully that question comes across well.
Yeah, that's a fabulous question, and it's certainly something we've been thinking about in the chair. Restorative was mentioned in the final report around Christchurch as being potentially a useful mechanism, but rather than simply thinking of it as, some of the survivors coming into contact with the perpetrator, which would be kind of a simplistic understanding of what restorative could offer, exactly as this question alludes to. Restorative could be done in community to tackle the ripples of harm that happened in Christchurch after the event, which are around racism and systemic racism. And, how we might do that work, of course, is like $1 million question. You want to be doing it in a way that has kind of tikanga Islamic kind of way of thinking about it, and you'd be working to we would be wanting to work in a co-design way in community to work out exactly what's needed and what restorative could bring. But yeah, that work around kind of unpacking racism is done a lot in America off the back of the Black Lives Matter movement. So we could do it here too.
Excellent, thank you. And I suppose I also have a question. To what extent does the chair and related agencies actually link what they do to the SDGs, and specifically to SDG 16 as a roadmap and as an internationally understood language, I suppose?
Christian, I'm sorry to say that probably not as much as we should or we could, and maybe this very presentation will be impetus for some change there. I think that one of the tricky things in restorative is that people come to it from very vastly different disciplines. And, you know, in our team, we have nurses and social workers and theologians and, you know, my background in psychology and criminology. And so, you know, and not as many political scientists and philosophers who might bring naturally that affinity to the human rights lens, but it is a universal. So I think we could do much more. So it's a good question.
Thank you. Right, we do have a bit more time for some more questions. I'll just jump in to fill this space for a minute. How have you found your shift over to New Zealand? Do you see distinctive differences between the Australian and the New Zealand approach? And if so, you know, how could you best explain that difference or describe it?
Yeah, okay. So yeah, I mean, the transition, even though it's just across the Tasman, it was quite a significant for me, bringing a whole family across. And so a lot of thought went into the decision. And really, it was around the fact that even though New Zealand and Australia have so many similarities, and both were called kind of a hotbed of experimentation in restorative back in the 1990s. It is the case that New Zealand is a long way ahead, partially because legislation kind of support a lot of restorative happening, but also because it's a smaller country. There's more recognition that something like restorative has value. You kind of see a pipeline effect where people, because you have restorative in, say, the PB4L program, which is in primary and high schools, people coming through that, then they get to university and there's something restorative at university, then they get to the workplace and there's, you know, restorative in the workplace. And then if you're unfortunately in contact with the criminal justice system, you're definitely going to see some restorative. And it's also used for very, very challenging crimes such as sexual violence through Project Restore. So for me, all of those levels of innovation and willingness to kind of use restorative made it very exciting and easy decision to kind of move over. Yeah.
Excellent. Thank you. Okay. Again, you're very welcome to add more questions into the chat box. Okay, a question from Margaret. How does the COVID-19 vaccine mandate for employment in certain sectors in New Zealand relate to justice and the United Nations Sustainable Goal? Very interesting. Do you feel that you can speak to this, Jane? Or
no, I think you should answer that one, Christian.
I'm not sure. I mean, this is such a politically laden and ethically laden question that I'm not sure that even the people who head up the UN SDGs may not have a ready response to this. It is, I mean, I think this will be debated for some time yet, but you know, there are a couple of dynamics under SDG 3, good health and well-being, and then there are other dynamics at play which might be pulling us in a different direction. So it is clearly a topic, I think, that will be debated in most countries. Beyond that, I'm afraid I can't add much value because it is not my field. Are there any other questions that you would like to put out to Jane? Okay, all right. So another question from Lewis. How can someone best navigate conversations with people who may claim that restorative isn't valuable or useful? What techniques can be used to persuade them of the value of restorative justice?
Yeah, that's a good question. And of course, there are many people who don't kind of have a natural affinity to the ideas of restorative, or just think it sounds too fluffy, too kind of wobbly as a concept to have much utility. And I mean, yeah, there are different ways you can tackle it. One is that you can look at the existing alternatives, of which there are basically none or very few, depending on what context you're talking about. You can point to what I do, being a social scientist. I tend to point to the evidence, which is around how it works and how effective it is, even in terms of reducing reoffending or satisfaction from procedural justice perspective. So I tend to use the evidence. The other strategy that you can do is to try and use the restorative questions, like what happened, the impact and the way forward. You can try and insert that into the conversation using, bringing something to mind and kind of unpacking it. The best way, often people come to it via doing it and then going, yeah, it's really good. And we have lots of, especially we do a lot of work with government and might be very skeptical. And you take the restorative model and you do it, and suddenly that you've got a bunch of converts. So, those are some of the strategies, I suppose, that you can use. I'm sure there'll be people here who are practitioners who would have many, many more ideas than me.
Wonderful. And a final question from Laurie. In the process of unpacking any case of systemic discrimination, do you use allies?
Yeah, without knowing exactly what the term allies means, as soon as you get any complexity to an encounter, like a harm or a harm or a crime, the restorative circle can be the restorative circle can be enlarged, can be bigger, to bring in as many people as you think necessary to support a good conversation happening. And you would be bringing in specialists, certainly if you're talking about something like sexual violence or family violence, you're bringing in people who know the attributes of those kinds of harms, and you're bringing them in to support a safe and useful conversation. And the same thing with systematic discrimination, that there are some complexities there and patterns that could be usefully unpacked by experts. So yeah, you bring in as many experts as you can.
Excellent, thank you. And a final question, I think truly final question now from Rosalind, but thank you for that additional question. What is the effectiveness of restorative processes in reducing reoffending in the justice system? So what are some of the stats, and how do the victims respond?
Yeah, so the reoffending metric is very important to every government department that I've ever met, and globally it's a metric that matters, and it matters to communities too, because you don't want more crime. And some of the evidence is mixed, but a lot of it, especially with more serious crime and in the post-sentencing space, is very strong that it does reduce reoffending. There have been some randomized controlled trials that support the fact that it has a significant reduction leads to a significant reduction in reoffending. Some of that literature sits in, there's the Campbell collaboration, which is a kind of a site which collects kind of good quality evidence, and that's a good place to look if you're interested in that. In terms of how victims respond, there's a very high, in terms of a justice mechanism, very high rates of satisfaction because people are having a say, very high sense of procedural justice because it's fair and equitable. In terms of whether it transforms lives, it depends on the severity of the impact and what else is going on. But certainly in terms of general satisfaction, yeah, it's very positive.
Wonderful. Thank you very much. After this really interesting presentation and then the discussion, I'd like to now draw the seminar, or this webinar, I should say, to a close. Thank you very much, Jane. That was really interesting. And I think we did have quite a range of attendees with a lot of backgrounds from both within universities, outside universities, and also our other universities around New Zealand and overseas. So not just Victoria. So thank you very much. Your presentation is much appreciated. And if I may, I would now just briefly like to share the closing slide, which is, because this is a speaker series, our closing slide is always an overview of who we have already heard from. And now Jane's took place today, so there's one more in December, which is the one by Professor Arthur Grimes. He is the chair in Wellbeing, and his seminar is a postponed date because it was initially affected by the COVID lockdown. So he will speak on the 8th of December between 5:40 and 6:30 again. And if you're interested in these topics and how the different topics relate to the SDGs, please sign up to our mailing list so we can get in touch with you in the future. All right, thank you very much. I appreciate everybody joining us for this webinar. And again, thank you to Jane, and I hope you have a great evening.
Thanks, Christian. Thanks, everyone.